relationship between the former head of AMI, David Pecker, who is going to be one of the prosecution's witnesses, and Donald Trump, along with Michael Cohen, and a meeting that went on at Trump Tower. And they want to establish that these headlines were passed through both Donald Trump and Michael Cohen before they were published in National Enquirer. They want to make sure that evidence is, in fact, submitted. They're talking about potential testimony from Karen McDougal. They say they're not going to get into the salacious details of what happened between Donald Trump and Karen McDougal, but they want to establish that Donald Trump had a one-year-long relationship with Karen McDougal while Melania Trump was pregnant with their child. They're going to talk about Dino Sajudin, who is the doorman at Trump Tower, and his testimony as well as to what he saw during that time. They're also talking about the admission of tweets that were sent out by Donald Trump while Michael Cohen was under investigation, the admission of those tweets as well. So there's a lot of back and forth going on between both Steinglass, who is the attorney for the prosecution, Todd Blanche, the attorney, as we well know, for Donald Trump, along with Judge Juan Merchan. We're watching what's happening in the courtroom right now. And again, Merchan usually is kind of weighing in as to what is admissible and what is not admissible after all of the evidence is laid out. One more thing that I do want to talk about, which is the Access Hollywood tape. The transcript of the Access Hollywood tape will, in fact, be admissible. However, they will not play the Access Hollywood tape, guys.
Okay, Yasmin, thank you. And stand by. Maya, what do you make of what's happening this morning?
So far, I make that the people of the state of New York are doing quite well in these hearings. That's the way I read it. Well, this is evidence. Remember, we talked about this earlier. Their job here is that they have to establish beyond a reasonable doubt that Donald Trump's intent was to keep from the voters of this country information about these affairs, the intent being the primary issue, right? I mean, the business records are going to help establish that. We talked about time as a witness, the proximity to Access Hollywood. You know, we're hearing about Hope Hicks, Kellyanne Conway, the fact that they may be, one of the things I saw in the tweet of someone in the courtroom, Norm Eisen, was that the discussion from the prosecution is that as witnesses, they were going to help establish that the state of mind of Donald Trump and the campaign was that this was damaging to them. This is in the same proximity of time that they're doing the catch and kill scheme that is underlying what jurors are going to hear about in terms of why business records were falsified. But we're also hearing the fact that they're going to hear the transcript of the tape to reinforce, look, this is what was going on, including in Donald Trump's mind when he was making these decisions, signing these, agreeing that he would sign these checks with a Michael Cohen with whom he did not have a retainer agreement, but claimed that that's what they were paying, and that it was the Trump organization paying part of this. That's what, they don't have to prove that the underlying campaign finance crime was committed, but it goes to his intent that he was trying to conceal, and that's a key word in this indictment. And this is all evidence that's going to help the people of the state of New York build that case.
Can I just ask a quick follow-up question? And Chuck, let me have you weigh in on this. If they don't, why don't they have to prove that underlying crime that has been alleged here when it comes to these being felonies? So we have, you know, the falsifying business records, which Trump has been charged with, which are misdemeanors technically here in New York. It's that secondary crime that he alleges they were trying to cover up by falsifying these records that make it felonies.
That's right. So the underlying crime is the falsification of business records. They have to prove each of those elements, and to Maya's point, by proof beyond a reasonable doubt. In order to take those underlying crimes, the falsification of business records, and turn them into felonies, they have to show that the falsification was done for some other reason. The other reason here include violations of state and federal election law. So they're not being charged with those other crimes. They're only being charged, Mr. Trump is only being charged with the falsification of business records. I hope that makes sense. This is something that, you know, lawyers will get, but I mean, I think about my sisters who watch MSNBC all day long, and I have to explain it to them again after I get off because it's not apparent sometimes to non-lawyers. Underlying crime, falsification of records. secondary crime, the thing you were also trying to commit, the violation of state and federal election law, you don't have to prove its elements in the same way.
So for us that aren't lawyers, somebody I'm thinking, and hello to your sisters, by the way. I want to thank them for their viewership.
They're going to appreciate that.
We appreciate it as well. Temidai, how unusual is what's going on? I mean, all of these issues of the tape, whether it's going to be accepted or admitted as evidence versus a transcript of it, haven't a lot of these things already been discussed and decided beforehand? Today is the day when we begin the process of finding jurors. Is this what normally happens?
So it does normally happen. Now, ideally, before you get to the trial date, you file motions in limine. These motions where you're trying to get these things handled by the judge beforehand. So this case moves on quickly. And if you're the prosecution or the defense, you want certain things handled earlier so it's not coming up the day of or in the middle of trial. You don't want in 3 weeks of the trial to have a massive argument over whether or not a key piece of evidence is admissible. So it is normal to handle before. Now, as far in the day of like today, this may seem like it's moving slowly because we're all pretty amped up, but this is pretty normal, and it's going to happen throughout the trial. Things come up, things change, and when I've done trials, you get up there, and at the end of the day, the judge will ask, anything else that you talk about? And you might say, oh, Judge, this other witness, tomorrow I have this issue. Or 2 weeks from now, we expect this piece of evidence might look a little different. We want your judge to have a ruling about that. So this is normal, and we're going to see more of it when the judge, outside the presence of the jury, is going to be dealing with these legal questions of how things could come in, what can come in, and what this trial looks like. I'm
getting word they are discussing the gag order right now in the courtroom. Let's go back to Yasmin Vasugian to get an update. Yasmin, fill us in.
Yeah, a couple things, guys, that I wanted to mention. I want to go back to what Maya was talking about a little bit earlier. I just want to kind of talk a little bit about how it's being seen as the defense and Trump team also getting a little bit of a win with not allowing the playing of that Access Hollywood tape, along with the E. Jean Carroll deposition also not being able to be admitted as evidence. So those are two key things to keep in mind. Todd Blanche, along with Donald Trump, are seeing those two things as a win today. And then also the admission, as I mentioned a little bit earlier, of the Michael Cohen tweets. Steinglass at one point says, defendant efforted to dissuade witnesses to cooperate with law enforcement. The court said an offer of proof is required. There were communications with Michael Cohen, as the evidence will show. And then he talks about some of the tweets that they want to be admissible in court, saying this: they are hoping Michael Cohen, this is a tweet from Donald Trump, during the time in which Michael Cohen's apartment was being raided, they are hoping Michael Cohen will flip. I don't see Michael doing that. Sleep well tonight. You have friends in high places. And then they go on to say Michael Cohen began to distance himself. And he says, the defendant switched gears and said, if anyone is looking for a good lawyer, I strongly suggest you do not obtain the services of Michael Cohen. Made up stories. Steinglass goes on to say, you should not prevent the jury from hearing these tweets now, this evidence now. And again, I just want to reiterate, right? We are 90 minutes into this thing, about an hour and 40 minutes at this point. We started half an hour late. This is supposed to be about jury selection. They're still going over what evidence here is admissible, guys.
Yasmin, what's going on with the gag order?
So what I'm hearing when it comes to the gag order, and I'm just looking through this. Go ahead. What are you seeing? Okay, so my producer, Andy, just passed me something. So prosecutor Joshua Steinglass is now going after Trump's recent attacks on potential witnesses, suggesting that Trump violated the limited gag order in the case. And he says this: the defendant himself has publicly embraced the public strategy of going after his perceived enemies. And I'd be curious to get the legal panel to weigh in on this, because there's going to be a lot of talk about this gag order, as there was in the other trials that we have seen play out as well. And whether or not the former president is going to continue, by the way, to violate these gag orders, and then what will happen subsequently. Mershon has not necessarily weighed in on the case that's being presented by Steinglass when it comes to those gag orders. But as soon as he does, guys, I'm going to let you know.
Thank you very much, Yasmin. So, Caroline, let's talk a little bit about that gag order and about the fact that the defendant here is just sending all kinds of information and allegations out as this trial begins.
Yeah, and interesting that he did it over the weekend, on the actual eve of trial. He had to know that that was going to take up some time this morning because obviously they would need to address this issue. The judge is in a tough spot here. No judge wants to be that, person that is the one to throw former President Trump in jail for criminal contempt. I personally just don't see that happening, but the judge's hands may be tied here. We've seen previous judges issue these sort of escalating sanctions, monetary sanctions. Yeah, so the first is, a tongue lashing, which by any other standard, any defendant would, sort of shape up or ship out. And then you would have monetary sanctions. And yeah, there is an option of putting him in jail if there's no other recourse. He may be the one defendant that, you just can't get to shut up, besides, literally prying his phone away from him. But, these are really thorny issues, and I don't envy Judge Merchan's position today.
And we will be watching to see how he handles this today after this discussion concludes. But let's talk more about the judge in this case, Chuck. Judge Merchan has 17 years on the bench. And let me remind everybody, he is the judge who handled the tax case involving the Trump organization, that one in which the Trump org was convicted. We saw Weisselberg convicted and pleading guilty, ended up going to prison for 5 months in Rikers. He got some credit for time served, so wasn't technically behind bars for the entire duration of that. But based on Judge Merchan, how he handled that case, Chuck, what do you expect to see from him and how he operates this courtroom?
Yeah, I've never appeared in front of him, Anna, but I've appeared in front of lots of judges, and I can tell you some are very, very good at their jobs. Some are not so good at their jobs. And in that sense, it's no different than plumbers and dentists and airline pilots. By the way, if you lose 2 engines over the Hudson, you want Sully Sullenberger in the cockpit, not somebody mediocre. Judge Merchan seems to be a good judge, a thoughtful judge, and to Caroline's point, a patient judge in a difficult situation. There's one thing, though, that's bothering me a little bit about what I'm seeing so far. And Timidayo is exactly right. These issues come up all the time. But I hate to see them come up when a jury is waiting, or in this case, a jury pool. You have 1,500 people who are sitting around waiting for the lawyers and the judge to make decisions that could have been made last week or next week, or when they're not sitting around waiting. But that aside, and that bothers me a little bit, I think he is a judge who manages his courtroom and manages it well. You can see, I've said often, Anna, I don't think Judge Cannon, the federal judge in the Southern District of Florida, is a biased judge. I think she's a bad judge. I think she's an inexperienced judge, but I don't think she's biased. Judge Chutkan, on the other hand, the federal judge in the District of Columbia, seems to be moving her case when she has it in front of her with some degree of alacrity. There are different judges are good at different things. Judge Merchan seems to be someone who can move things along, but we'll see.
And we'll see, with the pressures of having someone who is going off and saying all kinds of things, what the judge does if there is a gag order there and he considers that gag order to be violated.